On August 24, 2023, the U.S. Sentencing Commission made two important amendments to the U.S. Sentencing Guidelines retroactive, namely Amendment 821, Part A and Part B. Today we will examine Amendment A, which modifies the U.S. Sentencing Guideline 4A1.1, also referred to as a Criminal History Amendment or Status Points Reduction. Amendment A has an effective date of February 1, 2024, and it is estimated that approximately 11,495 inmates may qualify for potential sentence reductions under this amendment. Now, let's discuss the three key requirements for eligibility under the Criminal History Amendment. Requirement 1. The offense was committed while under parole, probation, in prison, or on supervised release. Requirement 2. A. Are the defendant's total criminal history points 2, 3, 4, 5, 6, or 8? If yes, a 2 criminal history point reduction may apply. Or B. Are the defendant's total criminal history points 10 or 13? If yes, a 1 history point reduction may apply. Please note, if the defendant's total criminal history points are 0, 6, 9, 11, 12, or greater than 13, they are not eligible. Before we move on to Requirement 3, let's take a moment to understand the difference between criminal history points and criminal history category. Criminal history points range from 0 to 13 and are a subdivision of the broader criminal history category, which is represented by Roman numerals 1 to 6. Okay, now that we understand criminal history points, let's discuss our final requirement. Requirement 3. Did the defendant receive a downward departure or variance at sentencing? If yes, if the original sentence imposed is lower than the new range, the defendant will likely not qualify. However, if the original sentence imposed is within the new range, the defendant will likely qualify. At this stage, eligible defendants may file a motion for resentencing under 18 U.S.C. 3582C. Utilizing relevant sentencing statistics and data can be critical to securing a reduced sentence from the court. The judge will most likely rule on these motions without a hearing, simply reviewing the original sentence and resentencing materials. While reductions are not guaranteed, the judge must consider the 18 U.S.C. 3553A sentencing factors when making their determination. Please note, there may be additional factors such as mandatory minimums that may disqualify a defendant. The Commission projects average sentence reduction of 11.7%. Average sentence may drop from 120 months to 106 months. If a defendant has 0 criminal history points, the defendant may qualify for Part B. Look in the comments for a link to our video guide for Part B. We hope this helped you understand the Criminal History Amendment a bit better. As you can see, federal sentencing is complicated. The path to resentencing under the Guideline Amendment starts with data and analysis. Sentencing Stats is offering a free pre-qualification tool, a resentencing calculator, and a sentencing data eligibility assessment. We recommend you visit amendment821.com or SentencingStats.com/amendment821 to get assessed. SentencingStats.com is a leader in federal sentencing data and analytics. Our platform empowers attorneys, public defenders, media outlets, and defendants with powerful tools, reports, and services to help maximize sentence reduction, both pre- and post-sentencing. We are a trusted resource for Forbes magazine, The New York Times, Washington Post, and Law 360. Remember, this is not legal advice, and it is important to contact an attorney or public defender to discuss legal issues specific to your case.